These are either very quick and boring,
It's full of excitement.
or they're full of excitement.
Yeah, I've been in there.
But chances are, there's at least a 5 or 10 chance you're going to tell that you're going to get somebody killed.
Right. Exactly. It's your fault.
You're going to get somebody killed.
Good morning, everyone. This meeting of the Escambia County Board of Adjustment for April 16, 2025 is hereby called to order. With 5 members present, we have a quorum. We have a little bit of business to do, swearing in of a new board member, Susan Carlton.
Please raise your right hand. Do you, Susan Carlton, solemnly swear or affirm that you will support, protect, and defend the Constitution and the government of the United States and of the state of Florida, and that you are duly qualified to hold office under the Constitution of the state, and that you will faithfully perform the duties as an Escambia County Board of Adjustment member, so help you God?
I will.
Thank you.
Will you please swear in staff?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Members of the board, copies of staff's resumes have previously been provided and remain on file for reference. The board has previously recognized staff as expert witnesses. Does anyone have any questions regarding their qualifications and abilities to offer expert testimony? Seeing none. The board meeting package for April 16, 2025 with the Development Services staff, findings of fact have been previously provided to board members. The chair will now entertain a motion to accept the BOA meeting package into evidence.
Motion.
Motion by Willie,
Second.
second by Randy. All those in favor of the motion, please raise your right hand. 5-0. The motion passes with 5 members in favor of the motion and 0 members opposed. Proof of publication, do we have proof?
Yes, sir.
Did the publication meet all their legal requirements?
Yes, sir.
The chair will now entertain a motion to waive the reading of the legal advertisement.
Motion.
Motion by Willie,
Second.
second by Randy. All those in favor of the motion, please raise your right hand. 5-0, no opposed. The motion passes. Members of the board, have you reviewed the minutes for the Board of Adjustment meeting held on January 15, 2025? Upon your review of the minutes, are there any additions, deletions, or corrections? Do we have a motion?
Motion.
Second.
Motion by Willie, second by Randy. All those in favor, please raise your right hand. 5-0. This motion passes. Willie, would you please read the purpose of the Board of Adjustment and conduct of the meeting?
The Board of Adjustment, BOA, hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are likely evidentiary hearings in the court of law, however less formal. All public testimony will be taken under oath, and anyone testifying before the BOA may be subject to cross-examination. All documents and exhibits that the BOA considers are entered into evidence and made part of the record. The giving of the opinion of testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. After hearing the testimony and arguments for and against the proposed action, and before making its decision, the BOA will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Because decisions of the BOA relating to variances, conditional uses, and extensions of development order for site plan approval are final, unless overturned by a court of competent jurisdiction. The county may issue development orders and permits for properties in ordinance with the decisions of the BOA. However, if applicant requests the issuance of any such order or permit, and such order or permit is issued, the applicant and not the county shall bear any risk that such decision may be set aside. The development order or permit may be revoked, or the development may be otherwise enjoined by the reviewing court. Any applicant for relief from a decision of the BOA for said actions or any aggrieved party, as defined by state law, may seek review of such decision by filing an appropriate pleading in the court of competent jurisdiction within 30 days of the BOA decision. The date of the BOA decision shall be the date that the BOA voted at the conclusion of the hearing. Whenever the BOA denies an application, no new application for the identical action on the same parcel shall be accepted for the consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an appeal of an administrative decision may within 15 days thereafter apply to the circuit court for review. Each individual who wishes to address the board regarding a particular issue must complete the blue request to speak form and submit it to the clerk of board. These forms are located on the table at the back of the commission chambers. You will not be allowed to speak until we receive one of these completed request to speak forms. We must have these completed forms for public record.
All written or oral communication outside of this hearing with members of the BOA regarding matters under review today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in Board of County Commission Resolution 96-13 before a decision by the board on any administrative appeal, variance, or conditional use request. The chair would ask, as each case is heard, that any board member who has been involved in any ex parte communication regarding the respective issue to please identify themselves. Thank you. And describe the communication. Our first case is CU 2025-01, 12385 Sorrento Road, a conditional use request to allow a drive-through within 200 feet of LDR zoning, requested by Meredith Bush, agent for Fishbein Properties LLC owner. Board, has there been any ex parte communication regarding this issue?
No.
Seeing none. Has anyone obtained information from a site visit?
No.
Seeing none. Does any board member intend to refrain from voting due to a conflict of interest?
No.
Seeing none. Would the individuals who are a party to this item please come to the podium and state your name and address for the record so you can be sworn in?
Good morning, Meredith Bush, 125 East Intendencia, Pensacola, Florida, 32502. I'm an attorney with Clark Partington and the agent for the applicant.
Good morning. Are you going to state the case, or would you like the county to, staff?
I'm happy to run through my findings. I do have staff's report, and we're in agreement with their findings. They're supportive of the request, but I'm happy to run through the criteria, however you'd like to proceed.
Do we have
Your
any
meeting.
public speakers? Mr. Chairman, we don't have any public speakers on this.
Okay.
Applicant's in favor and staff is in favor.
Board, do you have any questions for staff or the applicant?
Can we get a run through, get a staff report on what it is?
My name's Christina Smith, Urban Planner. This is for conditional use 2025-01. This is the location map for the property. And this is the 500 radius zoning map showing that it's commercial. And you can see the LDRs. Is this the right one? Okay, yes, I'm sorry. Make sure I was on the right case. And where it shows where it's backed up to LDR. This is the future land use map, which shows it's commercial. This is the AIPD map showing it's an AIPD 2. And here's the aerial map of the location. This is the notice of the public hearing sign posted on Sorrento Road. This is looking northeast along Sorrento Road. This is looking north across Sorrento Road. looking southwest along Sorrento Road, looking south onto the subject property. And then this is the notice of the public hearing sign posted on Bower Road. This is looking north on Bower Road. This is looking northwest at the intersection of Bower and Sorrento. This is looking west across Bower. And then this is looking south on Bower Road. And that concludes the photography.
Staff, would you take us through the findings of fact, please?
Sure. So the applicant is seeking a conditional use approval to allow a restaurant not among the permitted uses. For criteria A, the parcel directly abuts LDR zoning and requires a conditional use approval to allow a restaurant with drive-through service. The proposed use is compatible with the current zoning of the parcel and most adjoining parcels. The location is at the intersection of Sorrento Road and Bower Road, a major intersection. The adjoining parcel zoned LDR is vacant and is listed as wasteland and composed of wetlands and hydric soils. For criteria B, the facilities and services are available and will be provided as needed for the proposed use. The connection to these services will be reviewed at the development review stage. For criteria C, based on the submitted site plan, the new development will use the existing access points on the parcel. For criteria D, as shown on the submitted site plan, drive-through operations will be as far away as possible from the residential zoning. And then for criteria E, solid waste service must be provided as needed for the proposed use. Criteria F, if the conditional use is approved, the applicant must meet the screening and buffering requirements of the LDC. For criteria G, signs and lightings will be evaluated during the development review process and must be limited to what is allowed by provisions of the LDC. Exterior lighting shall be deflected from adjoining properties and public streets. For criteria H, the location appears adequate for the proposed use as proposed. And then for criteria I, LDC 3-2.10.3G states in part that the parcel boundary of the restaurant or brew pub with drive-through or drive-through service shall be at least 200 feet from any LDR or MDR zoning district unless separated by a 50-foot or wider street right-of-way. This necessitates the conditional use. The staff recommends approval of this proposed use as requested with the condition of completion of the DRC process and receipt of a development order.
Board, if I may add, just to kind of add to the explanation here. Sorry, Andrew Holmer, Escambia County Development Services. With our first iteration of zoning, along many of our arterial roadways, commercial zoning was extended off to the sides. Basically, they buffered out from the center line of the road and just put strips of commercial along arterials. You'll see this in certain areas, especially along Gulf Beach Highway. And then beyond that, just had residential zoning, lower density residential. When we consolidated zoning districts, we couldn't take rights away from anyone, and we crunched down the categories, so we are still left with situations like this in which along an arterial road you will have zoning that allows for things such as drive-throughs, but the immediately adjacent zoning is very low density residential type uses. Even though it may not be practical to develop in some of those properties, and especially in the southwest portion of the county, we still run up against this. So the way the code handles it is because of there can be nuisances associated with a drive-through. You know, it's going to have hours at night. You're outside ordering those wonderful speakers that sound like Charlie Brown's teacher to me. But that's why we're in the situation. We have two of these cases today. So just wanted to clarify that for you.
Thank you. Does the applicant have any further questions or information for the board?
I don't believe so. I'm happy to take any questions from the board. We're in agreement with staff's findings and feel that we meet all of the conditional use criteria. I won't bore you by running through them again, but, we feel like we've submitted a good application and would just ask for approval.
Do any board members have questions for staff or applicant?
Can you put up staff findings again one more time?
Is it time for a motion to accept, staff recommendations and approve?
Do we have a motion?
Motion
Motion by Willie,
Second.
second by Susan.
That motion
All
was,
board members,
yeah, that motion was to approve according to
Yes.
staff's findings, I'm sorry. Yes, sir.
board members, raise your right hand if you're in agreement. 5-0, passes.
Thank you.
Case number CU 2025-02, 8860 Pine Forest Road, a conditional use request to allow on-premise alcohol consumption within 1,000 feet of a place of worship. Requested by Beck Reed, agent for Desiana Properties owner.
Okay, we got some.
Good morning. No.
You okay? All right. Board members, any ex parte communications regarding this case? Any knowledge of information shared by a
I'm sorry.
site visit?
No.
Seeing none. Does any board member intend to refrain from voting? Seeing none. Would the individuals who are party to this item please come to the podium, state your name and address for the record so you can be sworn in.
Fernando Chavez. Board, I don't believe that the registered agent is here in person. If we could move on to the next case, and if he shows up by the end,
All right?
we'll hear it back.
Sounds fine. Okay, case CU 2025-03, 3451 Johnson Avenue, a conditional use request to allow an educational facility in the HDR zoning district requested by Clint Gessie, agent for Islamic Center of Northwest Florida, Inc., owner. Board, are there any ex parte communications regarding this case? Seeing none. Board, is there knowledge or information obtained from a site visit or other sources? Seeing none. Is any board member intending to refrain from voting on this case?
No.
Seeing none. All right, would the individuals who are party to this item please come to the podium and state your name and address for the record so you can be sworn in by the clerk?
My name's Clint Giese. The address is 2950 North 12th Avenue.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Yeah, thanks. Thank you all for hearing our case. Yeah, we're proposing a small school addition for the existing mosque on Johnson Avenue. It's with the conditional use request, we've provided all information to meet the criteria, and the staff's found that we have. And so really we're just here to address any follow-up questions that you guys have.
Were you presented a copy of the criteria?
Yes, sir.
And are you aware of the staff's findings?
Yes, sir.
Staff, would you like to go through the findings of fact, please?
Go for it.
Okay, good morning. My name is Melissa Shirley. I'm an urban planner 1 here in Escambia County. And this is case CU 2025-03. This is the map showing the location of the proposed educational facility. This is the zoning along Johnson Avenue surrounding the proposed location for the educational facility. This is the future land use surrounding the subject parcel. This is an aerial photo of the subject parcel. This is the notice of public hearing sign. This is looking west along Johnson Avenue. This is looking north across Johnson Avenue. This is looking east along Johnson Avenue. This is looking onto the site directly from Johnson Avenue. This is another photo looking directly at the existing structure. Okay. So today the requested conditional use is to allow for an educational facility in HDR zoning district. As to criteria A, the findings of facts are the proposed conditional use of an educational facility could be conducted and operated in a manner that is compatible with other properties zoned HDR as they operate at a lower intensity than other retail sales, retail services, public and civic uses. This will be an accessory use to the adjacent place of worship. An application has been filed to combine the two parcels for simplification. The parcel southwest of the proposed location share a common ownership, and similar requests for educational facilities within HDR zoning have been approved near this location along East Johnson Avenue. The dwelling structure that is present will be removed and replaced with a 9,000 square foot building along with playground areas. If approved, the site will be required to go through site plan review process with a development review committee for compliance with land development code standards. As to criteria B, if necessary, the applicant will apply for additional utility services, including power, potable water, and sanitary sewer to be coordinated with Florida Power and Light and Emerald Coast Utility Authorities. This criteria will also be scrutinized during the development review process. As to criteria C, ingress and egress proposed will allow for access heading east along East Johnson Avenue along the 2 points of entry. Additionally, there will be a proposed adjoining driveway to the existing driveway that is on the main center that will extend a parking lot and a drive-through drop-off area in front of the proposed educational facility. As to criteria D, the nature of the proposed use will not generate unreasonable adverse nuisances and hazardous impacts to the adjoining properties. The proposed site plan shows a 12-foot landscape buffer along the eastern and southern portion of the parcel. This will also be reviewed during the DRC process. As to criteria E, the applicant will use waste disposal that has already been implemented for the adjoining property. As to criteria F, the applicant has proposed, as aforementioned, a 12-foot landscape buffer along the eastern and southern portion of the parcel. This will also be reviewed during the DRC process. As to criteria G, lighting will be reviewed during the DRC process for any additional requirements. If there is going to be any requests for additional signage at this location, that will also be addressed during that time. For criteria H, the size of the lot is roughly 2.8 acres. The shape, location, topography of the site appears adequate to accommodate the proposed use of an educational facility with an expanded driveway and parking. Again, all of these requirements will be reviewed during DRC. For criteria I, there are no additional conditional use requirements, and all other land development code requirements will be addressed during the DRC process. And the staff's finding that they have submitted adequate documentation that addresses that conditional use criteria, and they meet it, and we would ask that the board approve this conditional use.
Does the applicant have any additional information you'd like to share?
No, sir.
Board members, questions for staff or the applicant?
On this picture that we're looking at right here, so the current mosque is the larger building to the left?
Yes, the Islamic Center is the one to the left, sir.
Yeah. And you're just looking to add a school to the right?
Yes, sir.
Board members, any other questions? All right, thank you, sir. We have several people in the audience who would like to speak. Randy Nash.
Good morning, how's everybody doing?
Morning.
I approve of it, I think it's a good
Mr.
thing.
Nash, Mr. Nash, I'm gonna have you state your name and address for the record, and I'm gonna swear you in, and then you can begin.
Randy Lynn Nash, Senior, 3349 McLean Avenue.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may begin.
Okay, I approve of it. The questions I have is, they own a residence there on McLean, and they're coming out through there. And if you add more cars, I mean, that McLean is real thin. I mean, two vehicles can barely get by each other, and that's a lot of traffic coming out through there. So are they just gonna be going on to Johnson, or are they gonna keep coming through McLean?
That has got nothing to do with us as the purpose of this, correct?
Well, in 2020, I came to one of these meetings, and they said they wouldn't come through to McLean when they bought that house, but now they're coming through. And so if they add this extension, or this add-on, there's gonna be more traffic coming through there. So, I mean, how do we deal with that as residents?
So
We did have a previous conditional use case on the property. It's the property immediately south of the current mosque.
It is.
Which does front McLean, as he said.
Yes.
This will need to be reviewed during development review because the site plan that we just had up shows a loop drive through there. There it is, right there. And that will have to be reviewed by our access folks when they come through with their official engineered plans. And just so everyone knows, in that area, you have a number of streets. McLean is one, Perazim, which is south of it. These all feed into Tippin. Tippin is, for want of a better word, a collector of sorts. It's still classified as a local road, but it serves as a collector. A lot of the traffic running between Olive and Johnson cuts through that way. You have several different neighborhoods through there that all feed in, just like McLean does, onto Tippin. And that's all going to be evaluated by our traffic division when we come through development review.
So are they
So-
do they still come through there? I mean,
As proposed on the site plan they've sent to this board,
yes.
it's just connecting through Johnson. It's going to have two entrances on Johnson.
So how will I know, or when will I know that they're either gonna come through or they're not? See, I mean, I don't care.
Sure.
Widen our road for us. I
So
mean, that's a good thing. They can expand our road for us. I don't have a problem with that. I just, the
Can't
road-
make those guarantees
The
for the
road,
county.
you can't have two vehicles go side by
Correct.
side. One have to, I mean, they're that, and so if you're adding more cars, we have kids and everything, and people on skateboards and stuff. I mean, it's
Understood.
dangerous.
So as you can see with that site plan, that's what they're bringing to this board. Now, I cannot, now, let's say the board was to approve it with this site plan,
Okay.
then that's the one they're going to need to follow.
Okay.
Now, if in development review, we come across some other situation in which, let's say there's life safety issues involved, let's say the fire department says, no, I need another access,
Yeah,
then
because
that
the
will
hydrant-
happen.
The hydrant is on the McLean side for them, believe it or not.
Yes, sir.
So
We are
they
not-
need that.
So this board can approve this as this site plan because
Okay.
conditional uses are based on that exact plan.
Okay.
What I'm trying to say is, in development review, if there becomes some sort of life safety issue that requires another access,
Right.
that will happen because that carries the weight.
Right.
But as of now, what's requested is what you see in front of you.
So what is resident do I do about the traffic coming through there? I mean, that's, right now at this point?
Sure. At this point,
I mean, what are my,
I would suggest you reach out to our traffic division. We have a county traffic
Okay.
division. There is a list of projects in each commission district for widening and paving and those sort of things.
so that suggests they are gonna be still be coming through.
It may be possible, depending on if it becomes a life safety issue. At this point, that, what you see on the screen is what they're
I
asking
mean,
for.
I'd love the road to be widened, I have no complaints about that.
Takes a lot of money.
Well, I mean, you know,
What we're here to discuss and
Okay.
and vote on today does not dump out on
What
that
this
road.
board is here to discuss is what you see on the
well, I
screen.
agree with that, I
Yes,
think
sir.
that's a good thing.
Yeah.
The traffic, I don't agree
Got
with,
it.
so.
Understood.
Thank you.
Yes, sir. Thank you.
In order not to mispronounce the next person's name, I'll just call her first name, Zenda. Hi, come on to the board and please be sworn in by the clerk.
Please state your name and address, please.
Zenda Swearingen. My address is 3800 East Johnson Avenue.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Go ahead.
Hi.
Good
Yes,
morning.
as I stated, my name is Swearingen. I own the property at 3800 East Johnson Avenue. I am not necessarily against the project, except I'm not sure that the Islamic Center is aware that this house is on the historical register for the county. I am aware of that because my house at 3800 was built by Mr. Johnson of Johnson Avenue, and there's a lot of historical information in that area. Okay, that land is all part of the John N. Rarity Land Grant of 1693, and there is some historical data in terms of some African-American freedoms and things that were given. I'm not against them building, I am against them destroying the house, because it is historical, and the previous owner, Mr. Thomas Roberts, he knew that when he sold them the property, and I'm pretty sure that he didn't tell them that the house was on the historical register. So I'm willing to work with them. I have been approached several times in the last 24 months or so by individuals in this town who would like to buy my property for restoration. It's not for sale for anybody, but, because I'm in the middle of doing that, but I think that there needs to be an effort to see if we could gain somebody that would be interested in moving the house and it not being destroyed.
Staff, can you clarify?
So within the county, we do have community redevelopment areas that have specific regulations when it comes to historical structures. This area is not within a CRA, but this would be an item that would be brought to that group's attention and those specific folks within the county. It's not a zoning matter, but when they come through development review, they will certainly be notified about that structure and take it from there. Like I said, it's not a zoning issue.
I'm sorry.
It's the nature of the existing structure of the house. It's not, there's nothing in our zoning code that applies to historical structures. I am aware of that, and the one you're in that used to be connected by a little trail to the Johnson property off of Pompano.
Right.
The other family property, yes.
Well, I'm pretty sure that they didn't realize that it is historical.
They may just now be finding out, yes, ma'am.
Okay, so we need to, I mean, I would be glad to work with them, but I think we need to make an effort to save that house and have it moved. Somebody wants to purchase it from them, but for it to be destroyed would be astronomically horrible. I mean, it just would be terrible.
And this is why we send out public notices, because we don't have all that information, so thank you.
Okay, thank you very much.
Thank you.
Board, any other questions? Seeing none. Is there a motion to,
So I move that we accept staff recommendation and approve the,
motion made by Randy,
Second.
second by Willie? All those in favor, raise your right hand. Unanimous, 5-0. Motion passes. All right, case number CU 2025-04. 10291 Sorrento Road, a conditional use request to allow a drive-through
I need to say something.
within 200 feet of LDR zoning,
Just in case if they ask me a question.
requested by Beck Reed, agent for Desiana Properties owner. Board, is there any ex parte communications regarding this case?
No.
Seeing none. Knowledge or information obtained from a site visit or other sources?
No.
Seeing none. Does any board member intend to refrain from voting due to a conflict of interest?
Mr. Chairman, on the agenda, we had a variance case before. If we can, do you mind if they proceed with this one, or, yeah, okay. It's fine.
Going back to number 2?
It's fine to continue as you are. I
Okay.
just wanted to check it with them. Thank you.
Get me sworn in.
All right, would individuals who are party to the item please come to the podium, state your name and address for the record, so you can be sworn in by the clerk.
Good morning.
Good
My
morning.
name is Beck Reed. I am the applicant representing Ufi Cheeto on behalf of McDonald's. We are located at 1008 Macon Street, Suite 101 in Fort Worth, Texas.
Please raise your right hand, and I'll also get Horace sworn in as well at the same time. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
I do.
Thank you.
Have you been provided a copy of the criteria required to obtain a conditional use?
Yes.
And a copy of the findings of fact?
Yes, I have.
You understand that all criteria must be met in order for the board to grant conditional use?
Yes.
Would you like to make a presentation, or would you rather have the staff?
If staff could present the findings, please.
Okay.
Okay, my name is Christina Smith, urban planner, and this is for conditional use 2025-04. This is the location map for the case. And this shows the zoning map, and you can see where the LDR is on the back of the property, and it's commercial. This is a future land use map showing that the property is commercial flu. This is the AIPD2 map. And this is the aerial showing where the existing bank is on the property. And you can see the property in the back, which is zoned LDR. This is a picture of the public hearing sign that was posted on the property. This is looking west along Sorrento Road. This is looking north across Sorrento Road. And this is looking east along Sorrento Road. And this is looking onto the subject property. And that concludes the photography. So for this case, the applicant is seeking a conditional use approval to allow a restaurant not among the permitted uses. For criteria A, the parcel directly abuts LDR, low density residential zoning, and requires conditional use approval to allow a restaurant with drive-through service. The proposed use is compatible with the current zoning of the parcel and most adjoining parcels. The location is near the intersection of Sorrento Road and Blue Angel Parkway, a major intersection. The adjoining parcel zone LDR is composed of mostly wetlands and hydric soils. For criteria B, facilities and services are available and will be provided as needed for the proposed use. The connection to these services will be reviewed at the development review stage. For criteria C, based upon the submitted site plan, the new development will use existing access points. For criteria D, as shown in the submitted site plan, drive-through operations will be as far away possible from any residential zoning. For solid waste service must be provided as needed for the proposed use. For criteria F, if the conditional use is approved, the applicant must meet the screening and buffering requirements of the Land Development Code. For criteria G, signs and lightings will be evaluated during the development review process and must be limited to what is allowed by provisions of the LDC. Exterior lighting shall be deflected and from adjoining properties and public streets. Criteria H, the location appears adequate for the proposed use as proposed. Then for criteria I, LDC 3-2.10 3G states in part that the parcel boundary of any restaurant or brew pub with drive-in or drive-through services shall be at least 200 feet from any LDR or MDR zoning district unless separated by a 50-foot or wider street right-of-way. This necessitates a conditional use. And staff recommends approval of the proposed use as requested for the conditional use of completion of the DRC process and receipt of the development order.
Does board have any questions to staff on this issue? Seeing none. We have two members of the audience that want to speak. Ben DeHaze.
That is for the variance case. This one should be under those.
Oh, gotcha. Thank you. Beck Reed, please.
And Beck is the agent.
Ex-agent, so.
Yes.
Is there another one?
We also have our engineer here, Patrick Bennett, to answer any questions you may have about the site.
Okay.
Okay.
Patrick Bennett.
So they're,
We're both just here for any questions you have.
yes.
Board, any questions?
So this looks exact same condition as the one we did earlier. I don't have any questions, and if nobody else has questions, I'll move that we accept staff recommendation.
Motion has been made by Randy.
Second.
Second by Susan. All in favor, raise your right hand. Unanimous. Motion passes.
Thank you all.
All right, back to case number CU 2025-02, I believe.
The connection we have to the agent in this case, the applicant, is still trying to get a hold of him. Can we move forward with the variance that we have? The folks are here. The
Sure.
variance case, yes, sir.
Shall we proceed then?
With the variance. We're still waiting to see if we can get the agent for that conditional use on Pine Forest.
Yeah, the
V
V
2025.
2025-02.
Yeah.
Yeah. All right. Okay. Case number V 2025-02. 4 Navy Boulevard, a sign setback variance requested by Den DeHaze and Lindsay Oge, agents for Patwell Company, Inc. owner. Board, are there ex parte communications regarding this case?
No.
Seeing none. Knowledge or information obtained from a site visit or other sources?
No.
Seeing none. Does any board member intend to refrain from voting due to a conflict of interest?
No.
Seeing none. Will the individuals who are party to this item please come to the podium, state your name and address for record so you can be sworn in by the clerk?
Morning, my name is Ben DeHaze. I'm at 5563 North Elston, Chicago.
Yes, sir. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Were you provided a copy of the criteria required to obtain a variance and a copy of the findings of fact?
I was.
And are you aware that all criteria must be met in order for the board to approve this?
Yes.
Would you like to make a presentation, or would you like staff to?
I definitely can't do better than staff. I'll wait till staff runs through findings and questions on here.
All right, fine.
Yes, good morning, board. My name is Caleb McCarty. I'm an AICP planner on behalf of the county. This is a variance case 2025-02. First, we have our location map showing the property at the corner of Navy and Barrancas here. The zoning of the property is shown to be commercial. And the future land use of the property is commercial as well. This is in a CRA district of Warrenton. This is the current aerial map of the property. And for our photographs, this is the notice of public hearing that we posted along Barrancas Avenue. We also posted, well, actually this is looking north onto the site from Barrancas. And we also posted a sign along Navy there. This is looking northeast onto the site from Navy. And this is looking southeast onto the site from Navy. We're now looking southwest onto the property from the rear of the property. That concludes our maps and photography. For staff's findings, we did find that it met all criteria for approval for the variance. If you would like, I could proceed with staff's finding, but would defer to the board's direction.
Board's preference to go through findings of facts, or?
Yes, please.
Certainly. So the requested variance, the applicant is requesting a variance for a reduction of the 10-foot sign placement provision concerning visual conflict to a 1 foot of the public right-of-way for 2 proposed signs, okay? Under criterion 1, special conditions and circumstances, our findings show that there are special conditions that exist which are particular to this site. The parcel is the corner lot, which is abutted by a principal arterial road along the western right-of-way of North Navy Boulevard and a minor arterial road along the southern right-of-way of Barrancas Avenue. According to the application, the overhead utilities provider requires a 10-foot setback, and movement of the sign would require the locations to be in the drive aisle of the site. The site is located on a corner lot of a recently approved convenience store site with gas pump canopy. The proposed sign along Navy Boulevard referenced in the applicant's submitted site plan as mid-sign A, located along the expansive right-of-way of Navy Boulevard, and does not appear to obstruct vision on the property, as the stop bar is located in the right-of-way of Navy. And we can show that on the site plan that was submitted by the applicant. The exit sign at this location is limited to right only. Vehicles exiting from this location would have clear visibility to the south to allow for a safe exit due to the stop bar's location in the right-of-way. Additionally, the proposed sign along Barrancas, referencing the applicant's submitted site plan as mid-sign B, would obstruct vision along the right-of-way between 3 to 5 feet as proposed signs or monument signs that are 12 foot in height. And we provided a rendering of those proposed signage as well. However, based on the approved site development plan, the exit at this location is limited to right only. And therefore, the proposed sign along Barrancas would not contribute to any visibility concerns for vehicles exiting from this location, as there would be clear visibility to the east to allow for a safe exit to the west. And we, again, provided a reference to the Exhibit A of the approved site plan that we can pull up shortly. Concerning criterion 2, special conditions and circumstances not resulting from the actions of the applicant. The subject property's current configuration and roadway frontage are pre-existing. The site is located in a Warrenton Community Development Area, and both proposed monument signs adhere to the CRA requirements for this area. Criterion A, concerning special privilege, our findings show that granting the variance requested will not prevent any other property in the county from requesting a similar variance to sign placement. The variance request process is available to all property owners of Escambia County. Criterion 4, concerning the provisions of the Land Development Code, our findings show that the on-premise permanent signage provision authorized by the Land Development Code in instances other than non-residential uses allows for the following signage of the Warrenton CRA. In summary, the Warrenton CRA is limited to 1 freestanding monument sign per development parcel, scaled primarily for pedestrians, and not to exceed 100 square feet in area and 12 feet in height, except for tenant development where the sign may be up to 300. Also, signs, colors, materials, lighting shall avoid adverse visual impacts on the surrounding property, and wall signage shall not obstruct design details, windows, cornices of the building to which they are attached. Our findings show that this location is approximately 1.8 acres and consists of 2 development parcels. Site signage is limited to 1 monument sign per development parcel. 2 monument signs are therefore permissible, 1 on each development parcel, so both as long as conforming to the area and height limitations of the Warrenton CRA overlay. The applicant's submitted rendering of the proposed signage has been found to meet the Warrenton CRA overlay requirements. Note that if approved, the freestanding signage for both development parcels will be exhausted, and no additional freestanding monument signs would otherwise be allowed without appropriate variance procedures. Finally, the sign variance must demonstrate the additional technical considerations outlined in section 5-8.2D concerning our variance related to impairment and legibility. Staff found that the additional technical considerations are demonstrated. The proposed placement allows the applicant to effectively promote commerce for the commercial site. In conclusion, the strict application of the provisions authorized by the Land Development Code will create unnecessary and undue hardship on the applicant. Placement further onto the site would hinder the safe movement of vehicles on the site, as it would not be located within the drive aisle of the approved site plan. Criterion 5, if this is the minimum variance that can be granted, we found that the requested variance for signage would be the minimum necessary to make reasonable use of the land. Further placement onto the site would impact the drive aisle and curbing. The proposed signage location would allow proper identification to promote commerce on the site. Concerning criterion 6, if it's consistent with the general intent and purpose of the Land Development Code, we found that granting of the variance would be consistent with the general intent and purpose of the Land Development Code and will not be injurious to the area or otherwise detrimental to the public welfare. Note that North Navy Boulevard and Barrancas are both under the jurisdiction of the Florida Department of Transportation. This variance request does not alleviate the applicant of any other authorizations or approvals, if applicable. And finally, for our staff recommendations, we do recommend approval of the request as submitted, with the condition that both signs must receive a valid Escambia County sign permit. That concludes staff's findings for this case.
Does the board have questions for staff or the applicant?
I've got a question for staff and filtering through this, trying to figure out, why it's here. And
sure,
it's not because it's 2 signs, because
correct,
it allows 2 signs. Is it the distance from the road that's the reason that we need a variance?
Yes, sir. The provisions in our sign code, we usually, when you deal with construction, houses and stuff, you deal with setbacks.
Yes.
The provisions as they read in the site code are not necessarily setbacks, but they're treated as such. There's something called a conflict, which states that for signage, if the signage is visible between 3 and 9 feet from grade, you got to kind of think of you sitting at a stop sign and looking that way or looking the opposite way. If there's a visual conflict between 3 and 9 feet, it's required to be 10 feet from the right of way.
Okay.
And so we treat it as a setback, but it's just easier to do that sometimes. But it is called a conflict, if you will.
Okay.
Visual conflict.
So the distance to from the street is the issue.
That's what the variance request is for.
Really, and
Perfect. Yeah.
And as long as it's not a safety issue that somebody else will pick up.
Yes, sir. And we found that, based upon, and that's why I was specific in the findings, that sign A being along Navy, the actual stop bar where a car would literally stop on the site is actually on the right of way. The right of way is, fairly large there. So a car wouldn't likely see a sign unless in a queue or something like that. And then the one on Barrancas, as noted in the findings, the driver, if you will, of a car should actually be looking opposite direction of the signage. So that's where we found that at.
Any other questions from the board?
If there's no further questions, Mr. Chairman, I'd like to make a motion to approve according to staff findings at this time.
Motion has been made.
Second.
Motion by Randy, or by Willie, and second by Randy. All in favor, please raise your right hand. Unanimous. Motion passes.
Mr. Chairman, the agent for the last remaining case is currently on his way. It is up to the board if you want to have a 5 or 10 minute break, give him some time to get here, or
Did he say 5 or 10 minutes he'd be here?
Yeah, you said he is on his way.
If you would, this is our third attempt to do this. The last time was because of you guys. You didn't have a form, so for God's sake, give us a little mercy.
Board?
He's out there calling him out, make sure he's.
I don't think we need a motion for this.
Yeah, I'm okay.
I think it's
I'm
just,
okay till 10:30.
I think it's just a common sense thing. We ought to give the man a little
I'm
mercy.
okay till 10:30.
10:30?
Yeah.
Oh, if he ain't about 10:30,
All right,
we'll go on recess.
yeah.
Thank you.
Yeah.
can I approach and speak to Miss Susan?
Sure.
How are you?
I'm good. How are you doing? Thank you. Good to see you. I know.
Yeah.
That's a good question. I wasn't sure where you were coming from at first.
So the first thing I always look is trying to figure out what we're doing, you know, why it's on here. Because like, you know, sometimes we'll have a thing in the, like the townhouse question. Right? If the two houses were here, then we wouldn't even be here.
Right.
The fact that they're touching,
They're still single family.
they're here. I mean, and so I always try to figure out what, you know, and
Yeah.
they just, I mean, that developer has been notoriously building, like, I mean, he's a slumlord.
Oh, really?
But
You too. You take care.
he just built, I was shocked that Circle K on the Garden and A Street maybe.
Oh,
There
yeah.
was a little one there, he just built the big one there. And when they started building, I'm like, man, that's gonna be awful, but they made it with glass, you can see all the way through, it doesn't look like, yeah, so it's, they have,
They're improving?
yeah, they started, yeah, cause they own they own more property in Warrington.
You're right, though, in looking back over the years, one of the things that doesn't happen is it's not explained to us why
Yeah, so,
the
and
need.
a lot of times it's a distinction without a difference.
Yeah.
That's, yeah.
I take it might be him, the one whipping up in the parking
Oh,
lot.
really? Is he whipping
Yeah,
there?
yeah, it's a truck just pulled in there. I mean, he came in hot.
Yeah.
show it the first time already?
Yes. But no,
This was
not,
a
not
separate-
this case,
Oh,
a different
okay,
case,
okay.
the mobile hi, it was the one on the
Okay.
mobile highway, no, no, no. Thank you. I appreciate it. I was, I'm gonna be real honest, I thought this was gonna be a 12:30 day, 1 o'clock day.
I had a hard stop at 1:30 and I had a backup that could come in, cause I thought for sure it was gonna go.
Yeah, so, if they need a 10-minute break, I'm cool with that. How's lunchtime?
Was that 20 and 30 minutes, so they asked for that 10-minute break?
I don't know if I wanna talk about it. I mean, it's up to y'all, if you guys are like, I'm done.
I'm happy, I'm cool.
I mean. Not kidding. I understand the flip side of it, cause they were supposed to come in February.
Yeah.
They were supposed to come in March, and now they are here in April, so. I feel a little bit. Yeah, I guess. I wasn't gonna say that.
Love is patient, love is kind.
Right.
And we love our community, we be patient.
Thank you for the positivity.
For the positivity of the day,
Yeah, yeah. I thought today was gonna be crazy, so I'm thankful.
Ain't over yet.
Well, I know. So I'm thankful for that.
We all missed. Sign.
Hello, this is Table.
I live in those districts, I live downtown, and I can do a darn thing without architectural.
Which one was this? Which one? Oh, I believe last we talked, you were gonna send over some photographs over there.
Approved colors. Actually, I'm actually yeah, I'm actually repainting right now. It's Western Flags.
Well, let me look at it, I got a meeting going on right now, and I will give you a shot here, just real quick. All right, yes, sir. Give me just a little bit. Leave it right now.
Justification.
Oh, I said justification.
No, you said it right.
I said, oh, but I
You
read
said it right.
Yeah, you said it.
Oh. Oops.
And all of us
Rachel
missed
here.
it. We all
I put
missed
it
it.
in there on purpose to see if.
All of
Every time you read it so many times,
Uh-huh.
you don't catch it until we're reading.
If it doesn't flag it, I'd rather old red
Oh,
underline.
yeah, I know.
Then I'm probably not gonna catch it.
I think our eyes just read it naturally.
Well, that's how I typed it.
Expected to see.
That's how I typed it.
Yeah, read it thinking this is how it's.
Yeah.
Right, yeah, but it was wrong. But the only person that would have caught it would be Laura, if we didn't hide it.
Right.
Man, I can't believe this is, with this case, there's been so many outside influences on this piece of property. Me and Rachel told him, you can have, everybody, you can have another agent, additionally, if that, because we know
Thank y'all very much. Thank you.
We're gonna let him get signed in.
So I owe you all something.
That smile good enough. You touch my heart when you say have some grace.
What's that?
You know, we all have to have grace sometimes, you know.
Well, I appreciate it very much. Miss Little, the landowner, appreciates it too. We've been trying to get this closed down for 3 months. I represent her, by the way.
All right, we're back in session. Case number CU 2025-02. Will the applicant please come to the podium, state your name and address, and be sworn in by the clerk?
The address of the property?
Your address, Fernando.
Oh,
Name and
yeah,
address.
it's 1750 West, 9.5 Mile Road,
Please-
Cantonment, Florida, 32533.
Please state your first and last name.
Fernando Chavez.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Were you provided a copy of the criteria required to obtain a conditional use and a copy of the findings of fact?
Yes.
And are you aware that all 8 criteria must be met in order for us to approve this?
Yes.
You have your choice I'm sorry. You have your choice of presenting your case, or you can defer to the county.
Okay. What? Yeah, we can.
All right, excellent, thank you. You have a seat, Mr. Fernando. All right, board, again, this is CU Conditional Use 2025-02. The request is to allow for on-premise alcohol consumption within 1,000 feet of a place of worship. The relevant authority is listed there, and we'll go through the criterion for this. Oh, excuse me, maps and photography first. Here we have our location map showing the property at Bush Street and Pine Forest Road. We have our 500-foot radius zoning map shown here. This is our future land use map of the property. We've demonstrated a site inspection map showing the location of the conflicting uses, being the church in the turquoise blue and the proposed location of the property there in red. We also conduct a distance measurement with GIS that demonstrates the door-to-door measurement of the facilities. And we also provide an aerial map for the file. This is our notice of public hearing sign that we placed on Pine Forest Road. This is looking south along Pine Forest Road. This is looking west across Pine Forest Road from the site. And this is northwest across Pine Forest towards Bush. This is looking north along Pine Forest Road. Also looking north, there is a automotive repair shop along Bush Street there in Pine Forest. This is looking on the site. This is currently a single-family home that's on the site. We also placed a public hearing sign along Bush Street there. This is looking onto Bush, or onto the site from Bush as well. This is Bush Street, an unimproved road in the county. This shows us the Redemption Church that is a little bit further down Bush Street. Yeah, next photo. And as you can see, we tried to get a demonstration of how those uses will be viewed from each other. This is looking towards the church from the subject property. That concludes our maps and photography. If you would, I would proceed with staff's findings. We did find it met all criteria for this conditional use request. All right, again, this is to request on-premise alcohol consumption within 1,000 feet of a place of worship. For criterion A, general compatibility, note that as prescribed in the LDC 4-7.5E, the Board of Adjustment for Alcohol Uses shall review the following in regards to the condition of general compatibility. Those include the existing times for uses of the place of worship or child care facility coinciding with the operations of the subject business. Also is to consider the 1,000-foot minimum distance is not achieved. Also, the conflicting uses are visible to each other. Any on-premise consumption is outdoors, and any additional conditions or circumstances that would mitigate any incompatibility. Those are particular for alcohol uses. We found concerning those, staff found that for number one, according to the signage along Bush Street for the place of worship, the Bush Street Church activities began at 10 a.m. and 11 a.m. Sunday and at 6 p.m. on Wednesday. A home is currently located on the proposed restaurant property. The applicant states that the specific hours of operation are proposed as Monday through Sunday, 11 a.m. to 9:30 p.m. The applicant states willingness to cooperate with any request from the place of worship. For number two, we found that the 1,000-foot minimum distance is not achieved. According to the county site measurements, the place of worship is approximately 400 feet from the proposed use. Note that the building is not yet constructed, and the measurement was taken from the existing home on the property. The proposed measurement of the restaurant building will likely vary from this measurement, and we provided a supplemental alcohol and measurement maps as seen. For three, the proposed use will not be visible, as the applicant states that the restaurant will be indoors with windows facing Pine Forest Road. The uses are further separated by Bush Street and trees. Incorporation of fencing and buffering can assist in mitigating visibility of the uses. The applicant is willing to comply with additional buffering to ensure visible compatibility, and the final positioning of the building can alleviate visibility concerns between the two uses. The applicant states that the proposed use will be conducted indoors with the open aspects towards Pine Forest Road. Note that separate, detached outdoor seating areas require conditional use review from the Board of Adjustment accordingly. There are conditions or concerns that would help mitigate any incompatibility. Ingress and egress will likely be limited to Pine Forest Road, as Bush Street is an unimproved residential road. A pre-application development review has been conducted with county staff, and per the preliminary site plan, no access is shown to Bush Street at this time. Concerning criterion B, facilities and service, staff found that the applicant states the facilities and services are available and will be provided as needed for the proposed use, and that the connection to these services will be reviewed at the development review stage. Concerning criterion C, on-site circulation, we found that based on the submitted site plan, the proposed development will establish access to Pine Forest Road, a FDOT arterial roadway. Any proposed connection to the state road must be reviewed and approved by FDOT accordingly. Currently, the existing single-family home utilizes access from Bush Street, an unimproved right-of-way. Additional right-of-way may be requested and associated improvements may be required if access to Bush Street is proposed. Additionally, on-site circulation requirements will be further assessed in the site plan review process and appear to be sufficient in accommodating the proposed use of on-premise alcohol consumption for a restaurant. Concerning criterion B, nuisance and hazards, we found that as shown on the preliminary site plan, the restaurant will be centrally located on the property. No nuisance or hazards are anticipated with customary indoor alcohol uses. Criterion E, solid waste. We found that solid waste service must be provided as needed for the proposed use. The applicant states that the dumpster will be located furthest away from possible pedestrian walkways. Criterion F, screening and buffering. We found that the proposed alcohol use alone does not otherwise require additional screening and buffering. Per review of the adjacent apartment complex site and plans, a 6-foot wood privacy fence with vegetative buffering is located between the apartments and the subject property. Those are provided in Exhibit A. The applicant states that the additional land abutting Bush Street will accommodate additional buffering if required. Criterion G, signs and lighting. We found that per section 5-9.3 of the Land Development Code, exterior lighting in and around buildings and parking lots is permitted in all districts. Lighting is to be located for safety and visual effect. With the exceptions of street light, it shall be installed as not to shine directly on adjacent property. Lighting shall avoid annoyance from brightness and glare. Furthermore, signs and lighting will be evaluated during the development review process and must adhere to what is allowed by the provisions of the Land Development Code. Criterion H, site characteristics. We found that the site appears to be adequate for the proposed use. Criterion I, use requirements. We found that our findings show that the alcohol licenses in the state of Florida require zoning verification from Escambia County prior to issuance. And this zoning verification will be restricted to the permitted uses of the HCLI and the HCLI NA zoning district per the Land Development Code provisions. No HCLI NA prohibitions as defined by the Land Development Code can be authorized. We provided clarification per section 3-2.11F, section 2 of the Land Development Code. Restaurants with on-premise alcohol consumptions are not found as prohibited use in the HCLI NA zoning district. The HCLI NA zoning designation states that any applicant for rezoning to the HCLI zoning district may request the HCLI NA designation prohibiting the establishment of any microbreweries, microdistilleries, microwineries, bars, nightclubs, or adult entertainment uses on the rezoned property. The request shall be in the form of a notarized affidavit that acknowledges this use restriction and affirms that this is a voluntary request. Once approved according to the rezoning processes of Chapter 2, the HCLI NA zoning designation and its prohibitions shall apply to the property regardless of the ownership unless the parcel is rezoned. Furthermore, per section 3-2-11B3, the parcel boundary of any restaurant or brew pub with drive-in or drive-through service shall be at least 200 feet from any LDR or MDR zoning district unless separated by a 50-foot or wider street right-of-way. Currently, the property abuts MDR property to the north, and as Bush Street right-of-way width is not determined, the property will require conditional use for drive-through services if proposed. Finally, staff recommends approval of the conditional use as requested with the conditions of completing proper alcohol licensing as required and the completion of the development review process and a receipt of a development order. That concludes staff's findings for this conditional use case. Yes, sir.
I want to clarify something so that we can make sure, because I know Mr. Chavez, he is a reputable businessman, so that he'll be aware that with this board, that we are just approving the restaurant, not for outdoor seating.
No patio or anything.
That's why I want to make sure so that.
Okay.
So I don't want something to come up on the end, and so I just want to make sure, because I want to make sure this is just for the alcohol for the restaurant and those other things. So when he comes through our process, he'll know what is expected of him.
Oh, thank you.
Are there questions from the board for staff or the applicant?
Yes, I have a question. Go back to the pictures. I need to get a reminder of the measuring process. And so, is there a street? Is that Bush Street? So the house currently sits on Bush Street.
Yes, it's got frontage off of Pine Forest and Bush
So-
Street essentially.
And so if I remember correctly, from the front door to the street, then down the street.
Yeah, the way the code reads, is that it's the, pedestrian walkway, pedestrian right-of-way. And for these uses being daycares or churches, it's measured from door to door.
So, I mean, this restaurant will be on Pine Forest Road. So the door will not be in that same location. It'll be.
Yeah, and that's what we wanted to make
It would
sure.
go all the way to the corner and then down.
It could.
Yeah.
It could, and the only way we can get there now is what we got on the ground, yeah.
So we don't have a site plan in this package.
No, we don't yet, but because the measurement, the way the code reads is we do it along the shortest route of ordinary pedestrian travel within public rights of way from main entrance of the place of business to the main entrance of the place of worship. Bush Street being in a situation where the property appraiser's section map does show 25 maybe feet of unopened, unimproved right-of-way in between. We just kind of went from where a building could be placed and the closest location to the closest location. You're not going to find a site on that parcel where it's going to be outside the 1,000 feet. So.
Any other questions by the board?
So no matter where the building would be, it's still gonna be 400 to 500 to 600 feet from the door of the church.
Correct. Even if you went from the southernmost, the most southwestern corner, I believe is where I even looked at it at one point, measuring from the southwest corner of the parcel, which is, obviously not where the door would be, it was still well within the 1,000.
In this church, it is currently open. They do have service there at this point. I see cars on this picture, but that doesn't mean nothing. It could be an old picture.
From my understanding, the church is functioning, and I believe the applicant has discussed this with the church, and they didn't seem to have any issues.
We have anybody here to speak?
I'm surprised there's nobody from the church,
Yeah, that's it. Yeah.
unless
Yeah,
they
if they
all at
objected,
work, because
yeah.
we do have these meetings during work hours. If since the applicant did get with the church, how was that communication with the church made as far as what's going on 400 to 500 feet away from their door?
I did not fill out the form to speak. However, I do have some petitions that were signed by the church and members, the pastor and all, most of the members, I would say, of the church.
So, just so you're aware, in a quasi-judicial process, testimony has to be taken in person. It would be up to the board if they wanted to accept a petition, but if someone's not here to testify, we can't really take that as evidence.
I did invite the pastor to come out. I think he was available to make it.
I don't feel comfortable even looking at that right now.
Yeah, I don't think we need to.
I feel like if the pastor was, if he was concerned, he would have came. Somebody to represent the church.
But he's not concerned, that's why he's not here.
Right.
Yeah.
Really for it. The way he worded it to me was that it's kind of a battle have one for him if we get this approval, because he's also seeking to do some kind of conditional uses for his space to add some buildings or something. So the way he was approaching it with me was, first of all, great, if there's a place for us to go grab some tacos after church. And also, yeah, that's a battle have one for him if we can get this approval.
I'm gonna pray for that pastor. I've heard enough. You either hot or cold. You either one of the two. And but we're not here for that today. But yeah, that's right. So that's my question. I'm a minister, but according to what we have just read and heard, and according to the church not showing up and speaking up for themselves, and the representatives of that church not representing the church, I motion to approve if there's no further questions at this time.
I second.
Motion by Willie, second by Randy. All those in favor, raise your right hand. Unanimous, 5-0.
My body screaming out it's not devil's juice.
All right, what's up for next month?
All right, the next meeting is going to be Wednesday, May 21st, and we do have 2 conditional use cases for that day. And that's it.
All right, if there's no further discussion.
What's that date?
21st. I don't think we don't need a motion to close, do we? Meeting is adjourned.